The Honorable Andrea Lucas. I added the honorable part, she's way too modest. The Honorable Andrea Lucas has served on the EEOC since 2020 when she was nominated by President Trump during his first term and confirmed by the U.S. Senate as a commissioner. Chair Lucas was designated as chair of the EEOC by President Trump on November 5, 2025, after serving as acting chair since January 2025. She recently was reconfirmed by the Senate for a term expiring in 2030. As part of her work educating employers, employees, and other stakeholders about the laws the EEOC enforces, Lucas writes and speaks frequently about hot topics in employment and civil rights laws, including DEI, women's sex-based rights, religious liberty, and pregnancy discrimination and accommodation. I read all of that verbatim because all of you know what happens when I don't read verbatim, so thank you for bearing with me. But I have to say, that was all very impressive, but not nearly as impressive as Andrea Lucas. She's not just the chair of the EEOC. I think that she has been a transformative chair of the EEOC, one of the most consequential civil rights enforcement officials that we have. Whether you agree or disagree with what she has done in every single instance, you cannot deny that what she has done has been more powerful and that she has brought a far more forceful approach to anti-Semitism than we have ever seen from that important agency. So I'm very honored to be joined by Andrea Lucas. This is not my first time working with Chair Lucas. This is not her first time working with the Brandeis Center. She has been a visible presence in the civil rights community in general, but also in particular for the Jewish community and for organizations that care, as she does, about anti-Semitism. Let me start with a little bit of level setting. I'm aware that there are in here some very sophisticated lawyers. There are also some non-lawyers. There are some people who could probably use a little bit of background on what is the EEOC. So could you give us just a little bit of general introduction or background?
Sure, thank you so much for that really kind and generous introduction. It's a privilege to continue to work with the Brandeis Center after we I think started pretty early in my first term. So the EEOC, many of you probably have heard of agencies like the DOJ, right? Department of Justice. Everyone knows what they do. You see them out there. I'm hoping that you've seen the EEOC as well, but we're a less common acronym. The EEOC has exclusive jurisdiction over employment discrimination laws like Title VII when it comes to private employers. So that means every business, just about, private universities, nonprofits, media organizations, anybody who's a private employer, a non-governmental employer, EEOC is the exclusive mechanism to have civil rights enforcement when you're dealing with employment anti-discrimination laws. We partner with DOJ when it comes to a state or local government. If we're talking about a public university, owned by a state, we'll partner with them there. But we're exclusive in the private sector. And that means that when you're talking about religious liberty at work, EEOC is your one-stop shop. We have litigating authority, and we also do the vast majority of our work is through voluntary resolutions and confidential investigations. So that's another reason why I really appreciate the chance to sort of level set, because while there are a number of public things we'll be able to talk about and I'm excited about, a huge portion of our work is quiet and confidential for the benefit of employees and for employers.
Thank you. So that's helpful to start, but what the EEOC has been up to lately has been rather extraordinary. Could you speak to some of the recent initiatives?
Sure. So I think that it's fair to say that this period of time in the second Trump administration, in just 1 year, I think we have had the most vigorous work that the agency has done its entire history. 60 years, we just celebrated this last July. This is the most vigorous period of work combating anti-Semitism. And some statistics to sort of back that. It's a pretty bold claim, but here's some statistics. In the first year of this term, the EEOC has brought 3 merits lawsuits. It's also publicly in court against the University of Pennsylvania in a subpoena enforcement action. It found cause after months and months of career dedicated employees working to develop cause findings against the University of California, which then served as the jurisdictional basis for the DOJ's lawsuit against that public employer. We've also landed the public conciliation agreement against Colombia, which is the largest ever religious discrimination settlement in the history of the agency's, again, 60-year history period, and one of the largest that we've had for any basis of discrimination in 20 years. And we've also had some other public conciliations on behalf of Jewish individuals. So you have, even if you just took the public lawsuits we filed, 3, how many lawsuits do you think that over multiple presidential administrations the EEOC filed on behalf of Jewish employees from 2014 to 2024, in the 10 years prior to the second Trump administration? 3 in 10 years. We have done in 1 year what it took 3-4 presidential administrations to do, and then we're also landing these massive settlements. So we are really prioritizing this issue. It's extremely important, and we're rising to the moment, because sadly, the need for this amount of vigorous action combating anti-Semitism is in proportion to the volume of anti-Semitism that we see in the world.
People sometimes ask me why federal officials in this administration today are so focused on it. Now, sometimes it's just a question. Sometimes there's an edge to that question, and that includes sometimes also there are judges who raise that issue, and there have been even recent newspaper articles right here asking that question. I've spoken with you enough that I have a sense of it. But as a person who is not Jewish, but who has a commitment to civil rights, could you speak personally for why it is that you have dedicated so much time and effort to the issue of anti-Semitism?
For me, religious liberty is a core thing the EEOC needs to be focusing on, and combating anti-Semitism is, of course, an integral part of defending religious liberty. In my perspective, religious liberty is a first freedom. It should be a foundational right, not a second-class right. Historically, we have seen far too often that civil rights agencies have given religious rights really short shrift. I think they have not prioritized them sufficiently. They have treated them as second-class rights. And I think in our country more broadly, many people have tended to think that that is not perhaps the highest or best use of these agencies. But when we look at the founding ideals of our country, religious liberty is at the foundation of that. You have George Washington making promises to Jewish congregations that they will have freedom and each person will sit under their own fig tree. It goes back to the very founding. So as we celebrate our country's 250th anniversary, as we across the board recommit civil rights enforcement at the agency to founding ideals, I think it's very fitting to have religious liberty be a major focus. And of course, that means protecting people of all faiths. And when you see large-scale discrimination, harassment happening, which is absolutely what I see and have seen for the last several years against Jewish individuals in the workplace and elsewhere, it makes sense that this needs to be a major component of our religious liberty work. It's very personally important to me too. As a Christian, I think it's really important for me to defend everyone's religious liberty, even if I am not Jewish myself. I think that's just such an important core thing for our country. So I'm very passionate about this work. And this isn't, a newfound commitment. As you mentioned, one of the first things that I led in my work during the Biden administration, I started in the first Trump administration, continued in the Biden administration. Within 6 months of my time there, I led the commission's first unanimous resolution, bipartisan unanimous resolution condemning anti-Semitism and emphasizing the agency's commitment to doing that, and then have continued to do a variety of outreach across administrations. So while I think that prior administrations did not sufficiently prioritize this work, this isn't a completely novel thing.
That's right. Now, some of that was abstract, and I hope I'm not overstepping if I share that in addition to having discussed these issues with you and having heard you speak, I've also been with you when we have both heard others discuss anti-Semitism and speak about some really awful things Jewish Americans have faced, and I've seen you react to it. And I would say that I have been grateful just by the emotion, and to have someone in such a leadership position who has such an emotional attachment and care about these things. So I thank you.
Thank you. many of the work that the agency is doing started out of commissioner's charges that I filed. So most of the work the EEOC does comes from individuals bringing their own charges. The Title VII Congress also gave commissioners a unique power to be able to bring a charge themselves. And it was really important to me that in the wake of October 7th, and I heard from dozens of Jewish employees absolute terror and horror about what they were experiencing in their workplaces, that I really feared that many people were not going to, in that particular climate, feel comfortable filing their own charges. And the advantage of a commissioner's charge is I could act as a shield. It would be my name. It would not be their name going to their employer. We could investigate under the cover of my name. And I was really thoughtful about that because of the level of fear that I've heard when we were on some of those conversations together and in other contexts. But it was a privilege to be able to do that. It's not enough to say never again and then not take action about it. I'm trying to do anything that was in the lever of my power to ensure that never again means never again.
Could you share any thoughts on how you view the IRA, or International Holocaust Remembrance Alliance, working definition of anti-Semitism?
Yeah, I think it's a valuable definition. I have to speak on behalf only of myself, not on the full commission, since we are a deliberative body. We also don't have substantive rulemaking authority. But that being said, multiple presidential administrations have recognized that it's a very useful definition to understand what anti-Semitism practically may look at. In particular, for me, thinking about that definition, I think it's quite useful to see that often we find activists on other sides, or people who have engaged in protests, or often violent, harassing protests, are using the concept that they're trying to distinguish between anti-Zionism and anti-Semitism. But a good example of this is the University of California situation, which again, the EEOC, after months of investigation and extensive amounts of work, found cause to believe that there had been discrimination and harassment there against the entire University of California system. And one of the things there, as publicly reported, was Jewish exclusion zones in which you had an entire barricaded city, basically in this protest, and you had people who were card checking someone about whether or not they were a Zionist or whether or not they were Jewish. And it's just completely hypocritical, I think, to say that if they were asking you if you were a Zionist, to say that wasn't anti-Semitism would be real willful blindness here. So I think that's a tangible, really egregious example of how some facts that I think the definition is shines a useful light on how anti-Semitism may practically arise.
When we talk about the EEOC, it's usually about the rights of employees against their employers, the duties that the employer owes to their employees. But at the Brandeis Center, when we hear from people who have workplace concerns lately, anti-Semitism workplace concerns, sometimes it's about their employer, but increasingly it's about their labor union, which is supposed to be acting on their behalf. It's often true about teachers' unions, but it's also about a wide range of other unions as well. Could you speak to the EEOC's role with respect to labor unions?
Sure. Many people, to the extent that you know anything about the EEOC, you think about it in the context of an employer's rights and responsibilities. But Title VII actually covers a variety of labor market players. So employers are one of them, staffing agencies or screening agencies, so recruiting managers are another part of them. And then the third bucket is labor unions. So we have specific standalone jurisdiction over unions to prevent harassment and discrimination, and arguably failure to accommodate as well in that space. But many people don't realize that, and we don't do as much publicly on that. It's a priority for me to bring some more cases and also do more public materials to sort of educate the public on that space, because I think there's a lot of people who are union members who don't realize that when they're suffering from harassment or discrimination, as a result of their union's activities, that they might actually have rights there. But you do. We have brought at least one lawsuit in the past, not in anti-Semitism, but in a situation where we sued a union in the last 5 years. But again, it is a rarer one, and we just need more people filing charges so we can help educate people better in that space.
On behalf of the Brandeis Center, I accept that challenge. You'll be hearing from us. So this is a little bit of a delicate question. You have been doing a lot to protect Jewish employees, and sometimes that's included formal legal actions. In those formal actions, you have typically demanded data. It's not unusual. Always enforcement agencies demand data. But when you've been demanding data lately, there has been controversy and even litigation about it. Could you give us any understanding, and I know there may be limits on what you can say, what you can't say, but give us a sense of what this is all about in terms of the data gathering practice and how it's been coming up lately.
Yeah, I'll speak at a high level of generality because there is ongoing litigation. Some of these things relate also to investigations that have been publicly reported on, but I can't confirm or deny. So the only time I can talk about an investigation is if we're actually in court on it or it is concluded and we're in court on a merit. So there are some that I can acknowledge because we're in a subpoena enforcement action on them, like the University of Pennsylvania matter. There are other things that are in the press and people have complained about, but I can't specifically speak about that. But as a broad matter, talking about what do we do? When we do a standard civil rights investigation, again, we have career employees who have been at the agency for 20, 30, 40. We actually have some who our longest recently serving employee just retired at 55 years. People who are stretching back to the very beginning of the EEOC. And across that 60-year period of time, one of the things we do is we collect information. Why? Because there is no other way to protect victims of harassment or discrimination unless you collect information about them. And our historical practice, unlike some other cabinet agencies, the EEOC is extremely I think everyone's worried about retaliation, but for us, our standard practice is we never collect information to contact someone on their work systems. So some cabinet agencies have different levels of risk taking on that. That's their call. Sometimes and sometimes you might be forced to contact someone on their work, but email. But for the most part, the EEOC's long-standing practice across administrations is to collect personal information because we want to make sure that there's not any employer monitoring of your email systems, there's no logs, that when you speak to a government enforcement agency, you have the ability to feel completely uncoerced or not pressured by your employer. Because the risk of retaliation is a real one. About 50% of our charges are retaliation charges. So what we do, we'll collect information about the class of potential victims. That's particularly important when we're dealing with a commissioner's charge investigation, where, again, I'm serving as the shield to protect a large class of potential victims, but we need to gather a broader sense of the specific identification of those potential victims. When I file a charge, I always have to sign that under penalty of perjury, that I believe that there's reason to initiate this investigation. So I have reason to believe that there are victims there, but I may not know all of them. And so there's going to be information gathering to try to find who's this class, how do we be able to talk to them, understand their experiences, and then potentially get them money. And so I think what it fundamentally comes down to is, at some point, either the government will know information about individuals related to their religion, or we will not be able to enforce the laws on their behalf. I understand the sensitivities around this issue. I understand why the controversies have arisen, but fundamentally, to some degree, the Jewish community does have to decide, do you want to have civil rights enforcement in this space? And if you do, there is no other way for me to be able to get money to victims who have been harmed, and I believe in many cases have been grievously harmed, unless I know something about someone's affiliation with a religious organization. And the same principle, of course, is true for any protected characteristic. I can't protect black workers if I don't collect information about the black workers who applied to a job or are employees right now who might be within a class. I can't help female workers, or you pick your classification, pregnant workers, right? All of these things are involving sensitive protected characteristics. That's the nature of civil rights enforcement, but we do have to have that information. I can assure you, though, that we understand the concerns and we take our confidentiality duties very, very seriously. Title VII provides for criminal penalties or anyone to disclose information in an ongoing charge to the public. So everything is secured under criminal penalty.
So just so I understand, when you are seeking data, whether from a university or other employer, in an anti-Semitism case, is it the same kind of data that you seek in other cases outside of anti-Semitism, or is it sort of a different kind of data?
The same kind of data. We're always trying to collect, if we're doing a class case, we're always trying to collect information about the class of potential victims. So if it's a race case, it may be looking for the group of Black workers or Hispanic workers, or whichever race we're working on behalf of for who are involved in the particular set of aggrieved individuals. Same thing for religious discrimination, et cetera. There are different ways to get at what data you need, right? You could even be also looking for witnesses who aren't necessarily a class of aggrieved individuals. But in each case, you're trying to find standard investigatory information so you can know who might have relevant information and who might potentially be entitled to recover from their employer.
So you've been asking essentially the same kinds of information that the agency historically asks about, but the public hasn't been hearing about it so much because the EEOC wasn't looking into anti-Semitism as much. Is that fair?
Yes.
We have some practitioners in the room, some lawyers and others working in generally in the anti-Semitism space. You spoke a little bit about interest in labor cases in response to one of my earlier questions. To practitioners, do you have any comments on the sorts of cases that you would like to see or that you would encourage people to bring?
Across the board, to the extent that the agency has historically done religious accommodation cases, we tend to do garb, grooming, and religious observances. So whether it's a Sabbath day observance or another religious service, those are all good, worthy. We're going to continue to do that work. But of course, there are other ways that you might need a religious accommodation, including ones that relate to religious beliefs. So I'm very interested in developing more cases there, and that means people need to understand that when they have a conflict with a religious belief or value that conflicts with a work requirement, that they feel comfortable that they could file a religious accommodation request to their employer and then potentially bring a charge if that's denied. And I'd like to also just see more harassment and discrimination in terms of differing treatment types of claims. So we find that the more you do a particular type of public action, the more people know that they can bring a particular type of case. So we've got lots and lots of Sabbath day observances. But the other kinds of misconduct is happening. It's just people, I think, either haven't internalized that it's something covered by the law or that they could actually do something about it. So I'm here to say to you, our doors are open. We're here to take those claims seriously. We'd like to hear from you if you're having it. I have generally gotten the impression over the last 5 years that the agency has both sometimes given Jewish employees the sense that they're not the right kind of plaintiff, and so people have been not reaching out, and or people don't realize that these laws cover them. But you are the right kind of plaintiff. Everyone's the right kind of plaintiff. Our doors are open to everyone, and so just across the board, I'd just like to see more people filing charges, because I think that the number of charges that we receive is not proportionate to the volume of anti-Semitism that is happening right now. The best way to protect both your rights and a broader set of individuals' rights is to actually stand up. I know that that's frightening, but it's also really important. You can protect many people's rights by standing up and speaking up.
Speaking of your doors are open, so a question, any messages for students or early phase professionals, including, are you hiring? And if so, in what areas?
Yes, we're hiring nationwide. We also have interns. Our interns are unpaid. I'm sorry, it's the government. But we have paying jobs as well, and we're hiring for trial attorneys and investigators across the country. And we have locations in over 50 locations across the country, including in Boston. I'm going to visit our field office later today, and we'd welcome investigators and trial attorney applicants just about everywhere. So if you know someone who'd like to come do really important work on behalf of Jewish individuals and other workers of faith and a host of civil rights work, we'd love to have those applications.
In a moment, I'm going to ask if there are questions, but let me just ask before that, is there anything else you care to share?
I think we covered a good range, but keep watching our space. We've got a lot going on.
Fantastic. Thank you so much, Andrea Lucas. So there are microphones circulating around the room. I'll let Jackie find this table.
Hi, my name's Julie Paris. I'm with Stand With Us, and this has been really helpful information. Just two questions for you. Number one, when someone goes to file a claim with your commission, and they potentially are working also with an organization or a private attorney, could you explain just how those two paths merge or are divergent, and whether it helps or hurts their case, and also whether or not you work with state human relations commissions that may also be doing this investigative work?
Yes, I'll answer the second part first. Yes, we partner with hundreds probably at this point, dozens at least, state, we call them fair employment practice agencies, but they have all different terms. Civil rights commissions, human rights commissions. So we do partner with states, and we share workload with them depending on what comes in. People should typically be filing with the EEOC as well to ensure that you're getting your federal rights protected, but we do partner with states. And then in terms of attorneys or working with organizations, so you have a couple different routes. An individual is more than welcome to file a charge unrepresented, pro se, with the EEOC. And again, we have trained investigators and attorneys who will talk them through things and investigate on their behalf. But they're also welcome to retain private counsel, and if they do that, there are some advantages in terms of we do have an attorney filing portal where you could directly file your charge. We typically don't let individuals who are unrepresented directly file a charge before having an interview, which can take a little additional time, but because they're serious, right, this is actually exhaustion of your remedies, and it will go to your employer. We want to be able to speak to the individuals first, tell them if they have a potential claim, make sure they understand the ramifications of what they're doing, whereas you could get that with your attorney. So there's an additional timing if you're filing unrepresented. Either way will ensure that you have the chance to file your claim. But if you're represented, again, you just basically, the individual will have you listed as a representative. The other option you can do, and lots of people don't know about this, is a third-party charge. And so an organization like Stand With Us or the Brandeis Center or other organizations can file a charge themselves on behalf of a group of employees. And as long as they have one identifiable employee that's within the class, they disclose that confidentially to the EEOC, but that doesn't go to the employer. So that's a way that advocacy groups can also act as a shield for their clients to the extent that they're, or other aggrieved individuals that are particularly scared of retaliation or other security risk related issues. It's a way that you could file, and then that disclosure of the particular individual will only go to the EEOC, not to the employer. Typically, when an employee is filing a charge or a union member, et cetera, that while it's completely confidential for purposes of the EEOC, it does have to go to the employer. They get notice, they file a position statement, so they have the ability to have a response. So there's some level of disclosure to the employer.
And I'll also say the Brandeis Center, as Chair Lucas suggested, does in fact have, we have employment and labor lawyers, and so we're happy to represent people who either want us to represent them individually, or who would like to be part of a case that we bring as our own charge, or whatever works best for them as well. Dane?
Yes, thank you, Andrea. I was hoping that you and Ken would explain something, because many people here, I think, are civilians, and even if they're lawyers, they may not understand the role of Title VI. And this is something that's so interesting that Ken, many people don't remember, left Brandeis on a hiatus to become the head of the Civil Rights Division of the Department of Education. And at just about that time, Elon Carr was at the State Department, and something huge happened, which is that we finally understood what the word nationality was for Title VI purposes. And I don't think the room knows how that was a sea change for both Title VI and Title VII purposes, because it's really an answer, an antidote to the dual loyalty charge that if you're being discriminated as a Jew, it's not because you're a dirty Jew, but you identify with the people of Israel. That having Zionist beliefs to be discriminated against, that is a civil rights violation. And I don't think people understand that it's that very idea that the State Department elevated nationality. And I think this is all under your work, both you and Elon. And I think that most people don't understand that changed. That probably makes it a lot easier for Andrea to be able to invite these cases and prosecute them.
Well, actually, Title VII always had religion. It's certainly useful. There's so much overlap between education and the employment space, and I do commend Ken for the work that he did and others to expand that in the Title VI space. But Title VII, at least, historically has always had religion explicitly in there. Obviously, anti-Semitism can sound in a variety of bases. Maybe not so obviously, actually, I should say. I think most people know that they could bring it under the religion hook in the statute of Title VII. But you're right that you could also have nationality considerations or even race, depending on how someone identified. And I think that people should explore whatever basis they think is most appropriate for their situation.
And I will step out of the moderator role to respond to the portion that relates to me. So the Civil Rights Act of 1964 is what we're talking about. That is the big major statute that was such a landmark in federal civil rights. It had several different big provisions. Title VII, the one that establishes workplace protections against discrimination. The one right before it, Title VI, which prohibits discrimination on the basis of race, color, or national origin in institutions that receive federal aid. That was at the time, and to some extent still, the big one, because in 1964, the biggest single civil rights issue facing the country, I would argue, was racial segregation in the public schools. So it was Title VI that was the big one at that time, and something happened that is big for us, but that passed almost unnoticed at the time. While Title VII for the workplace has religion together with race, color, national origin, sex, et cetera, in Title VI, Congress took out the word religion. And so then the question became, well, what happens for Jews when Congress passes a statute that doesn't speak to religion in the context of our schools? Our K-12 public schools all receive federal money now, and almost all of our colleges and universities do as well. Until about 22 years ago, the federal government generally refused to pursue claims on behalf of Jews, arguing that Jews were a religion and religion wasn't covered. During the George W. Bush administration, I established a policy under which ethno-religious groups like Jews, but also some others, Sikhs, Muslims, et cetera, would have the same degree of protection as groups that had ethnic or ancestral background but not a shared religion. That was a policy that for 20 years we've had to fight for. It was elevated to the level of an executive order under President Trump during the first term. But a difference between Title VI and Title VII is that Title VII has always had religion, and Title VI we've had to fight for protection of the Jewish people in a provision that didn't explicitly mention religion.
Well, we're talking about differences between Title VI and Title VII. One other thing I do want to just emphasize, it's probably something you kind of heard or assumed from my discussion about recovering money for people, but my understanding is generally Title VI is more about focused on injunctive relief. It's not really about monetary recovery. You've seen maybe some other agencies recovering fines to the U.S. Treasury. I just want to be very, very clear. EEOC is a remedial statute that focuses directly about getting money for specific victims. So every single dollar that we recover, not a cent goes to the EEOC, not a cent goes to the Treasury. It's all going to specific individuals, aggrieved individuals who were employees, had an employment relationship, or a union member if we're talking about a union matter. So that's really important and really powerful, and it's a reason why if you're in an educational context and you have both a shared Title VI and Title VII claim, don't forget about the Title VII claim. You may want to pursue, for strategic reasons, Title VI as well, but Title VII is your path to compensatory damages. So and back pay potentially. So I encourage people to not underestimate the power of an employment claim.
Sure, and that's a fair distinction. It's not as if money damages are never available under Title VI, but often the cases focus on injunctive relief, and money damages aren't necessarily as easy to quantify in student cases as with employee cases. With employee cases, there are lots of different reasons why you might be able to determine how much of a monetary loss someone has suffered.
Mm-hmm.
One more question and then
Hey, Ken. Hi, I'm a professor at the UC system at Berkeley. I'm actually one of the ones you filed complaints against the UC for, so thank you for doing your work. Although I'm not one of the UCLA ones, so I don't get to intervene. But I wanted to ask a question and get your thoughts on something that goes on at many universities, but I've seen particularly at the UC, which is, the role of DEI in this is tremendous. And the way that it works at the UC system, for example, I'm at the law school, and so last year we did 3 searches in social justice, right? And you know how that plays out, right? And so there's a whole apparatus at the universities, including the presidential fellow programs at the UC, which apparently has nothing to do with diversity, but has fed sort of all the social justice candidates into the UC system. And I just wonder, in terms of looking at this, because you're talking about filing individual complaints of people who complain, how do you sort of look at those sort of like backdoor sort of end runs around sort of DEI, and where it's hard to even find complainants because people just won't apply, or the search is defined to do that, and how you're looking at that going forward?
I can't talk about UC specifically because to the extent that there is or isn't an investigation, I can't confirm or deny it related to DEI. But I will say more broadly, yes, I am very concerned that DEI policies have actually often turned into exclusion policies, and they are often using or blending that into anti-Semitism. I think that's a very real concern, where this is just a new version of figuring out how to blame Jewish individuals, and I generally reject identity politics, and I hope that our country can move past them. I think DEI policies have resulted in real, too often, actually race or sex or religious discrimination. It is always hard to bring a large class case and to have to seek claimants in a hiring case. But we do it. We do it in lots of other patterns that are more quote unquote traditional forms of discrimination. So I think that some of the question is, are we going to say we're going to try here too, right? The agency for decades has brought large hiring class cases on behalf of Black workers. We should continue to do that work where we have good support for it, but we should also work hard to find it in other aspects. So if it's a different fact pattern, whether it's white workers or Jewish workers or a combination thereof, or anything else, the agency's found ways to investigate these cases before. It can do it again, and there shouldn't be, we'll only do this for a particular preferred set of plaintiffs. So, I'm trying to widen the aperture. We can look at statistics. Even though the agency is not prioritizing disparate impact claims, that does not mean statistics are not relevant. Pattern and practice claims still look at statistics, and they combine it with policies and practices, other circumstantial evidence of discrimination. So there are ways for us to look at broad levels of statistics, applicant flow data, et cetera, and to look at representation data, and then combine it with things like looking at information about a company's or university's DEI policies, or interviewing their management witnesses, interviewing brave witnesses who are willing to tell us about what they are seeing on the ground, and to be able to combine that with statistical evidence to be able to build a case that there's a pattern and practice of discrimination, which is a theory of intentional discrimination. So while it's always harder to bring those cases, I think they're worthy cases for us to be focusing on. We are going to continue to work on pattern and practice cases on behalf of everyone, including Jewish individuals.
Again, thank you, Chair Lucas.
Thank you.